Owusu and Ivan Kyei innocent as Sanija Agu former attorney general Godfred Damiso. Almost here Sedina Tamakula say appeals court where we need the case now Nama Bontini na as a free woman. Yes, papa no. Na prosecution or no evidence no more ha. Enti Solomon Owusu on the crampo there. Reported about Bontini were reading the appeals case, you know. He was very angry, not the boy for papa. But kind document and the judgment in the way and was I don't know, say the innocent person question prison. And the defense na anya some get to. And then Ivan Kyei innocent to bam not Ghana had him so yes say sika rough. Adentina Godfred Dami aye case ni basama area say ono no hu ni say obi a was get ni ko chef yes wa fa no adi. And abusia pani be think about 28 minutes. Men skip baby a hwema nsi. Na nya ho ntia right here on Sokatwa show. Oba subscribe. We are bell notification icon button on video no drop here on Sabeka. Feel free to leave your comment in the comment section. Oba share link you know. Na for enye bi a share. Back home assist some case minchro say abusia for abruchire na uye project bi Ghana hanum say but you want an eye professional group on be monitor project no akọ evaluate the report abroad pictures be a situational report ya miss any detail of a project na oye no empram na na amanfo abruchire no the project bi share abusia for nsa omonamfo nsa Ghana hanum say ya omoye project na omokọ na omoye ne basa we enye say ekosi dan ama wo edan yesi honom but woni hanti no anka wo hanka abakọ hwe say dan ekosei omuguso omoye eno ntina back home assist abase o friend numbers na gu screen so no and so log into backhomeassist.com abusia ye be ko honom na yakọ make sure say contractors no mu si dan no the only juma dey na share say o ye adwuma no ewe ya approve you and you register and your who kwanya e wo hu tumi say wo the juma dey show bi say no nye ye betimi akọ na yakọ make sure say o ye ye timpacho friend numbers na gu screens na any omu endu juma obakwa na wo school na wo ni Ghana hanum say na wo professional group bi mama akọ sra oba no e the report aba the academic status na to say o ko school no ekoyi ampacho backhomeassist.com and that's the numbers na gu screens free ye be de ho and that's ye be di juma na e the amount Lel Flower Green Clean Solutions at Asamen Cultures and a power and you clinic company and mama be di jumana mount abe prepare o fee honum hospital church bank institution sorry dem honum office where the father dan kakra bi na bejo na ye twa ne yopo e de ama me se adwuma ho te se obi a woni ye adwuma bi e di ho adanse ye chiri kwan we adwo so ofri akra na obaku ma se adwo so traffic light no try apɛ won sani fa so abdusa to so 12 ase opɛ won sa ebeka. It's a good time now to go and listen to the submission. Ivan Kyei innocent youth activist any Solomon Owusu said almost yesterday jagu MPP4 and go for them so
it's part of the appeal process.
Let me be frank with you that the entire Sedina's case, I mean, from the High Court, I didn't have the benefit of reading the High Court ruling. And so some of the dispositions were not informed. And so my disposition was that she has to come back home. In fact, I've been on your set.
Yes, I recall.
Countless number that she has to come because she had been convicted. And once you heard a public position and you absconded and you were convicted, she had no business whatsoever staying in the United States. So some of us fought for it that she has to come. In fact, there was an extradition process that had started way back in 2024, and so through that she came and. We were excited. At a point, we were told that she was not even behind bars. We raised that we questioned those that were making those claims. They could not substantiate it. So, to my mind, she is behind bars. Now, when the Court of Appeal came with their ruling, I was somewhere doing papapa. Then my brother, Ebu Bokman, sent me breaking news from one of the media outlets that Sedina Attorney Tamaklo has been acquitted and discharged. Instantly, I was boiled up. I was so furious that why should that happen? And so we were going to go ballistic. But something struck us. Look, hold on, wait a minute. You must be a wise person. You must hear from both sides. You have listened to or you have heard from others why she must be there. But why don't you take your time and get the full ruling or judgment to understand the reasoning behind what the three judges did?
We're saying, yes.
So I waited for like 3 hours and thankfully I got the full judgment. And I have it here. It's a 94 judgment.
So you printed that?
I expended money.
Wow.
To print it.
You're always complaining about money, Solo.
The little that I get, I use it to print. But you are not buying me printer.
Okay. Okay.
So I printed it, binded it,
Yeah.
and took 4 hours
To read it.
to read it. When I read the judgment,
Yes.
immediately I became scandalous. I said, what? Why must why must we sit down for innocent souls to be done in this manner? Look, so quickly, because it's politics.
Yes.
I know the nuances of politics. I went back to check the judges that sat on this matter.
On this case, yes.
3 judges.
Okay.
Justice Emmanuel Ankama,
Yes.
Justice Samuel Obindiewu, and Justice Emmanuel Senyor Amedai. Do you know Justice Emmanuel Ankama?
You'll have to explain that.
Oh, that is the Sampa, the new Sampa mine.
Oh, right.
He was appointed by President Akufo-Addo to the Court of Appeal.
2022.
2022. Do you know Samuel Obindiewu? He was appointed to the Court of Appeal in 2022 by President Akufo-Addo. Emmanuel Senyor Amede by President Mahama in 2025.
October.
So this is what we are dealing with. Well, that cleared in my mind because you must deal with it.
What are you implying by this?
No, because you see,
Let's see.
immediately it came, the first impression was that President Mahama and this administration has introduced
Right.
their judges to go and then give a very fictitious or wrongful judgment to save one of their own. So that was the first angle I needed to look at it. Having established that, then I went to the decision whether or not it was unanimous or 2-1 or then it was unanimous. I said, then let me take a critical look at it. Sedina Tamaklu was accused for causing financial loss to the state, stealing, conspiracies to steal, improper use of state property, or what do you call it?
In fact, the number of counts are...
It was 7 but when you drill it down, it becomes about 8.
Right.
9.
9,
Yeah.
yes. Now, beyond that, when you go into the judgment,
Yeah, so...
charges 5 to 71, my goodness. That we had an attorney general that went to court and did this. No substance, no clarity, contrary to what Article 19.2. And let me read for you to understand what we are dealing with.
Yeah.
And this was a matter that somebody is supposed to go to prison for 10 years. Look, the mere fact that we are saying you must prosecute, and by the way, this attorney general must take a cue from it. The mere fact that we know people have stolen. If you are doing a case, make sure you do a watertight case so that nobody gets away with that.
What are you implying? That the attorney general... Which attorney general?
Godfred, total waste of our time. And not him alone, not him alone.
No.
The judge just sat on this matter. The judiciary must take a second look at it. I'm telling you. If this is how they come by their conclusions, if this is how they disregard the laws of the land. So Article 19.2,
Yeah.
with your permission, I read. 19.2D.
I hope it's got something to do with Godfred, because you retract that statement if,
That what?
if there's no substance.
But the judges have said, what the judges have said, what the judges have said in this judgment is to the effect that we had a very...
No, because you're mentioning his name categorically.
ineffective, inefficient, incompetent attorney general, as well as the judge that sat on it was incompetent.
You read.
Let's get this straight. So Article 19.2D.
Yes.
Is it Article 19, first of all, a person charged with a criminal offense shall be given a fair hearing within a reasonable time by a court. Now the D says, be informed immediately in a language he understands and in detail of the nature of the offense charge. Now if you go to charges,
Yes.
Count 5 to 70. I won't, because of your time, sometimes you want to manage or micromanage us here. I will just quickly go into some of the charges and you understand why some of you must be furious. So count 5.
Yes.
I'm coming on.
So this is a judgment.
This is a judgment.
Yes.
I have it here.
Oh, okay. Yeah.
I don't know why you just... Give me some few minutes. I will get there.
So I'll put you under fire today.
No, you have to put me.
Look, so why are you mentioning Godfred Ami's name now?
No, Godfred Ami, he has a letter here. I'll address it.
Yes, I was about to tell you about that letter. If you read, okay, you.
So let's say
Yes.
count 51.
Okay, I'm
count
giving
51. Yeah.
I'm giving that to you.
Willful causing financial loss.
Yes.
Section 179A of the Criminal Offences Act 1960. Particulars of offence.
Yes.
Said that Tamaglu, Ationo, Daniel Azimo, on or about 25th August 2016, Accra, in the Greater Accra region, willfully caused financial loss to the state of 158,000 to the state. What is this?
That is the particulars.
That's the particulars. And when we say particulars, let me read it again. This is count 51.
Yes.
51.
Yes.
Statement of offense. Willfully causing financial loss to the state contrary to section 179A3 A3A of the Criminal Offences Act 1960, Act 29. Now, particulars of offense. Sedina Christian Tamakluationo.
Yes.
Daniel Axim, on or about 25th August 2016, in Accra, in the Greater Accra region, willfully caused financial loss of 158,000 to the state. You ask yourself, financial loss to which institution? Well, how did they do it? How did it come about? What was the location? This is what Article 19.2 requires. So when you say this, how do you expect the person to come and say, I committed anything?
So how is this Godfred Dami's fault?
He did this. He preferred all these charges. Now, so the court identified that there were defects in the charges. To that extent, they struck out from 5 to 71 all those charges. It was just frivolous, it was scandalous, it was just waste of everybody's time. So it was waste of paper.
Direct question. I'm saying, how is this Godfred Dami's problem?
Oh, Godfred Dami is the one that went to court and did this shoddy work. And remember, you see, it must prick your mind. When Sedina Tamaklu came to this country, what were their communicators saying? They told you that the court was going to overturn the ruling.
Yes.
Is that not the case?
Yes.
That was their mantra. Because they themselves saw the judgment at the High Court and realized that it could not stand the test of time.
So, are you aware?
Yes.
That Godfred Dami is telling us
yes.
at the time this case started,
yes.
he was not
yes.
the Attorney General of the Republic.
No. That is another unseriousness. Let me tell you. Sedina Tamaklu was incarcerated somewhere April of 2014, 16. Yeah. No, 2024. 2024. Is that not the case? Mm-hmm. Yeah, April of 2024. Yeah, sure. By 9th of May 2024, the lawyers had filed an appeal.
Yeah.
The mere fact that saw his...
They gave notice that they were going to appeal. They are well within time, I agree.
They had appealed.
But I'm asking you a question.
Yes.
That what has this got to do with Godfred Dami?
Because
he was not Attorney General at the time this started.
Let me put it in simple terms. When anyone goes for an appeal, in simple terms, the person is going for, if you're a student, you are going for remarking.
Yes.
That a lecturer had marked your work and you believe that the lecturer did not do well and that you got more marks than what you were given. So it was Godfred Dami's work together with Justice
Godfred Dami did not charge Sedina Tamaklu.
No, he did.
No, I mean, he wasn't Attorney General at the time. He told you the beginning, the genesis of the case.
Yeah.
At that time, and you have that statement.
No, the statement.
Is that not what you've printed?
No, he is talking about the appeal, that he wasn't the Attorney General during the time of the appeal. I'm saying that at appeal you don't provide fresh evidence. It has to do with what was adjudicated at the High Court. The court of appeal only takes the judgment at the High Court, all the documents that were presented, and then make a determination on that. Let's go into the matters. Sedina Tamaklu, we were told, had expended 90 million cedis, had led this country to lose 90 million cedis. And when you look at the charges, the colossal amount involved was about 61 million that was involved in the GPR2 transaction. That Maslow together...
So what are you telling me, Zulu?
No. Let's educate our people this morning. That the 61 million Ghana cedis, Maslow and GPI2 signed a contract to provide them with 350 cars.
How is this Godfred Dami's problem? I want you to retract that because...
Which one am I going to retract, Godfred Dami?
I'm telling you...
I mean,
look, he could take you on for this.
I would be so happy. Look, there is a case that I have not made mention of it. The day, and I will not mention the name of the case, I will not talk about it. The day the appeals court will decide on that matter, that is where me and Godfred Dami, it will be all over. Because see, certain wrongs have been done against personalities, against their human liberties, that the society knows of it, but we have kept...
Have you read a statement from Godfred?
I read it and it's not... Look. Yes, you see, his statement even gives the MPP out. What were we told by J. Bafo and his people? And I have heard a lot of MPP people say that the records of proceedings or the exhibits, some of the documents that were supposed to be transmitted to the appeals court were never done.
That was said in Parliament by Bafo.
And I listened to Godfred Dami himself. This is his letter. You can check whether it is not from him.
No, I want to be sure.
Cross-check.
So this looks like what I've seen on Facebook.
Give it to me.
But
Now
today is
you-
colored. Today is
You want to spend money to print color, you don't even appreciate it. Now, paragraph 8 of Godfred Dami's own statement.
yes.
The Court of Appeal, you know this case when it started,
Yes.
the lady that was presiding was Her Ladyship Mensa Dacha. You understand?
Yes.
Now, the Court of Appeal, presided over by Her Ladyship Mensa Dacha J, proceeded to inquire. In fact, if I read it from you will not even understand. Let me start from 6.
Yes.
This is Godfred
Yes.
Dami
That's the
speaking.
statement. Yes.
My understanding is that the prosecuting state attorneys were surprised when they were served with the written submissions of the accused appellant on 16 February 2026 because they had no prior notice of the pendency of any proceedings. Nonetheless, they put together written submissions in opposition to the appeal and applied for leave from the Court of Appeal to file same, which they did on 9 April 2026. Now, 7. In their written submissions, the principal state attorney repeated complaints about an incomplete record of appeal. Are you taking notes?
Yeah, so that's where it emerged.
And the omission from the record of all the exhibits tendered by the prosecution at the trial and the fact that they became aware of the instant proceeding after the court had directed the parties to file their written submissions. Now listen to the 8. The Court of Appeal presided over by Her Ladyship Mensa Dacha J proceeded to inquire into the fundamental matters raised by the state attorneys which affected the court's jurisdiction to determine Ms. Attorney's appeal. By ordering that, listen, this is Mensa Dacha ordering that 3 volumes of the record of appeal, which the Republic did not have access to at the time it filed its written submission, be given to the Republic. Now, when she ordered this, listen to Godfred.
Yes.
This was done.
I have the judgment here.
You have the judgment there?
The judgment, yeah.
This was done.
Yes, the rectification.
The matter was adjourned. So those that are going to town with that fact that there were some exhibits that were missing, these are all pure propaganda.
So the court had provided opportunity for
Everything. And let me say that I don't know how you want us to proceed today because this is a matter that must take the entire time. I'm not interested in your next topic.
I know.
I want us to deal because it is very dangerous for you to put an innocent soul behind bars. What I'm saying is that all this noise has come about because Madam Ationo has cornered from this country.
So in your submission, there's only one challenge I have.
Needless.
There's only one challenge.
What charge do you have?
I'll come back.
All right, I'll be on standby.
And it's because that you've spoken for almost how many minutes? You've not mentioned the name of the Attorney General of this Republic.
But
you don't see him as doing anything.
No, but but let me say that
particularly when President is telling you that he wants to AG by this time.
The AG must not waste anybody's time and tell us that he's going on appeal. He must not go and spend every one city.
But I'll come back.
That will be woefully costly financial.
I'll come back to you on the AG.
All right.
Yeah, Blessed.
Yes.
Yeah, good morning and good morning to your viewers and to Solo as well. I think on a normal day, if you wake up, considering the journey this country has taken upon itself to ensure that the regime of accountability will become very effective in this particular country, and we are at the point where somebody has been convicted for almost 20 good years, right?
Oh, you mean Chairman?
Yeah. So when you are on that particular point, you get energized, get motivated that this regime of accountability is in effect, and that whoever that have doubt about this whole concept of being accountable will be convinced that yes, indeed, at this point in time we are on course. So if you wake up a day and you hear that somebody who has been convicted has been acquitted, definitely the reaction will be rage, anger, resentment, and those kind of ways. So politically, I think this whole thing might look like a shit show, and people are likely to get angry because of the space we find ourselves. So politically, if anybody out there is angry about this particular acquittal, it is because of the circumstances and the platform we find ourselves in. And people might not be interested in whatever the judgment say, whatever that the judge found, whatever. On the onset, that anger can be accepted or is acceptable because of the situation and the circumstances we find ourselves in. And I think that is the reason why you saw those massive outpouring of resentment, anger, and those kind of stuff on various social media platforms, and then many of the reactions that followed. So for me, I can perfectly understand, because personally, when I heard on that she has been acquitted, I was very furious, just like Solo said, very angry. But you see, if you pause if you pause for a second and begin to look critically at the judgment and then begin to inquire as to what exactly happened or what occasioned this whole thing, then you begin to have a different understanding and a different thought altogether. Because the platform we find ourselves right now, if you look at the atmosphere, like I said, it's very charged. Ghanaians are in for blood, and people are not ready to listen.
You and Solo this morning, I don't know. Who's prepared for? I mean, what are you guys saying?
No, I am saying that the atmosphere calls for the reaction. That's what I'm saying.
What reaction?
You think Ghanaians are demanding accountability? Look at the pressure people have been heaping on government for ORA to work. You understand? So at the back of it, if somebody has been convicted, and you wake up a day and you hear that the person has been acquitted, the public anger and the reaction, that is why I'm saying that it's justifiable within that particular context. Don't be mischievous. That is a fact. That is exactly what you're trying to do, because the mindset of the people is tuned to revenge. They want to hear nothing but people. Because over the years, people are convinced that political actors have taken the people for granted. They've taken us on a ride. And when it's time for accountability, people will actually have to be accountable. Like I'm saying, if you pause for a second upon all the anger and begin to review the document, then I am not sure anybody will read this particular judgment and come to the same state he was before reading.
Absolutely.
Have you read the judgment?
I have. I am saying that nobody will read this judgment and come to a conclusion. And after reading the judgment, nobody can also say that Sedina is innocent.
Okay, at the same time.
At the same time, she is not innocent. Just that somebody did a poor job.
So we can't say the evidence.
Somebody did a poor job. So I can confidently sit here and say, per the ruling and the judgment and the consideration, the fact, everything, she is not innocent. But somebody did a poor job, and the judge who sat on the matter could not in any way.
So if you're not innocent like you are.
Okay. No. You see,
if you're not innocent like you are, then what's the opposite?
In criminal prosecution, it's not just about whether you are innocent or guilty. You need to prove beyond reasonable doubt, not foolish doubt.
But Sedina cannot call herself innocent.
For me, if you look at the circumstances, she cannot. But you see, to convict somebody, there are certain standards that must be proven, and the standard in criminal prosecution is reasonable beyond.
So who is doing this poor job, by the way?
Which poor job? So let me tell you.
Yes.
An accused person has been charged on almost 7 categories of offenses, different. Stealing, conspiracy, money laundering.
70, isn't it?
Then you come back to draft almost 78 charges. And because people were in the haste, the numbering was wrong, and the judge dealt with it. Yes, it was 80. 80. That is the rush and the
49, they jumped to 52.
And blessed.
When we're counting the
yes, on the charge sheet there was a mistake on it. So,
but I mean, this is a no.
But the judge deliberately took his time to discuss that, just to give you a notion the bad job that was done. First of all, 78 count. In criminal prosecution, you need to prove every single doubt beyond reasonable doubt, and that is a Herculean task no serious prosecutor will bring upon himself. In the Owusu case, the count were 6. So you realize that proving it become easy. But if you jump up, we call these charges trump up charges. Let's put them together like a cha-cha prosecution. So that if this one doesn't pick, this one will pick. If this one doesn't pick, this one will pick. So it becomes...
They're playing cha-cha in court.
Oh, exactly. It becomes very hollow and weak. So they did not do us a favor. Because of their inefficiency in the way the matter was handled, somebody who's supposed to be in prison today is walking free because on technicalities, and there is nothing that can be done.
I thought you said that the fact that she's not innocent.
Yes. I'm saying that she's not innocent. The mere fact that she's not innocent doesn't mean that the judges had enough basis to convict her. And you see, just to prove a point, let me just take you to the judgment.
Which part of it?
The judgment, let me take you to 103.
Yes.
The prosecution case was that the appellant, then Chief Executive Officer of Maslog, caused to be paid to herself a sum of 164,000, blah, 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 to represent an unused leave commuted into cash and ex gratia. It was further alleged that she authorized payment of 109 by way of ex gratia to Mustafa Abubakar Barima. The grave man of the charge was that both payments were made.
The government, you mean?
The government.
Yes.
Payments were made without verification and in accordance with existing procedure. It therefore lay upon the prosecution to prove beyond reasonable doubt that the two payments were contrary to identifiable and applicable verification procedure. The procedure that required proof of both procedures said to govern these payments and of precise respect in which the appellant breached it.
My point is,
let me make a point.
Let him go and do the Q&A, the question and answer. Go to the question and answer.
The evidence of PW5, the head of.
First of all, establish who is the PW5, the head of finance of Maslow.
So this is the Q&A.
Okay.
So you tendered
PW5.
PW5. It says you tendered exhibit A, C, and AB, which relate to payment of end of year ex gratia to AI and her former deputy. Is that correct? He said yes.
So the finance officer is confirming that payments have been made.
Yes.
To Sedina and the deputy.
Yes. And then the payments were processed by your office. Is that correct? Yes. The processing was based on documents relating to the appointment of A1 and her deputies. Is that correct? Very correct.
Then what was the question?
Then in processing the payment, did you notice anything untoward? No, I did not notice anything untoward.
Who's saying that? The finance
director. And who is the prosecution witness for the state?
Come now, I need to understand.
Yes,
the finance
director. It's Q&A. He's on the witness box and they were asking him questions.
You were being cross-examined.
So you put your signature.
Ivan, which document are you reading?
The judgment, have it.
The judgment. Do you have that document?
No, take it.
Okay, no, give it to her.
The substance of my point, I haven't even gotten there.
You haven't? Okay, no, get it for me.
So I authorized those payments and did not find anything wrong with that. But listen to what the judge said. That the evidence does not establish that the appellant authorized the impugned payment. On the contrary, PW5 accepted the payment were processed by his office. They were found upon the appointment documents of the appellant and her former deputy and issued by the Chief of Staff Office of the President. He observed nothing untoward in the process and he authorized the payment because he found nothing wrong with that. There was no evidence, that is the court talking, that the authorized payment were the authorized and improper payment. Still less, she procured it by deception, misrepresentation, or the presentation of false documentation to the office of
head of
Yes, the prosecution accordingly failed to prove beyond reasonable doubt the appellant was responsible for any unauthorized payment contrary to a verified procedure. The conviction and the sentence on this count cannot stand and set aside. Blessed. So if you walk through some of these trump-up charges, exaggerated, inflated, crafted out of emotions. Sometimes you look at the quantum the woman has taken and say, hey, then you craft charges. That was emotionally motivated kind of charges that were crafted out of the quantum. And at the end of the day, they could not provide any reasonable.
You see how Solo is happy that you're all making.
I'm making this point.
That's the truth. This is
and there is something that if I find it, you'll be shocked.
There's another part.
You'll be very shocked.
A lot of parts.
Ivan, how did you find all of this? Okay,
it's in the judgment.
Okay.
It's in the judgment. But I'll take my time. So what I'm trying to say.
I hope you're taking note of the points. And anyway, wait, hold on. Let me say good morning to the two gentlemen joining us. Awal Mohammed is
yes.
Hold on. At least say good morning.
Propaganda.
Awal Mohammed is a member of the National Communications team of the New Patriotic Party. Solo's former political party.
Which is that?
And then we have Dr. Samia here from the presidency joining us. I just want to.
I understand.
Let's say
we are speaking for 17 minutes.
I know. Come now.
Who asked you to come there?
No, just to.
Personally, I am angry that the woman has been acquitted. If I don't tell you, I'm lying. I'm very angry. Very, very angry. That is the fact. But the fact of the matter is that there was a case where the prosecution said she did authorization without she signed a document without authorization.
Yes.
And the judge said that because the charges were framed in negative, then the positive will be on the woman to prove beyond.
So now the defendant becomes.
How is that
This
possible?
is where I have a problem with the two of you.
Okay.
Listen to my problem here, my challenge here. That by virtue of the fact that this woman left the shores of this country,
yes,
we could not corroborate evidence.
Yes.
You agree?
Yes.
No, you must not agree because in criminal matters, if you are accused,
why didn't she return?
If you are accused, you don't have anything to say in court.
No,
you can be in court and
why are
keep
you
quiet.
just blaming Godfred? If you indeed agree that it's a whole process.
I agree with you. The woman deciding to stay and everything, that is what has generated it.
Because in the Owusu case, Owusu help corroborate evidence. And that's how come the judge was able to establish circumstances.
But he was not supposed to do so.
Yes, but I'm saying.
But
that
you see,
if
you also understand that the entire criminal jurisprudence is built to favor criminals.
Then.
Oh, how?
Oh, yes.
No.
Oh, yeah. That's true.
That is supposed to.
No. I am telling you on authority.
The burden of proof is on the state.
Yes.
It doesn't mean it favors criminals.
But I'm telling you, sir, the entire criminal jurisprudence favors a criminal because the proof beyond reasonable doubt. When it comes to proof,
presumption of innocence doesn't mean that you are guilty. You can't say
let me make a point.
Why are you not mentioning the woman's name? Because she also left the country.
That one has been.
But I'm discussing the judgment. The fact that she was left is not in the judgment. We are discussing I'll come there. But my point is that the entire criminal jurisprudence is built to protect criminals.
No. I mean,
let me tell you, because if an accused person is brought before a court and he decides not to speak, even if Sedina were to be here and that he decides to do it like this, still the prosecution will have to prove their case beyond reasonable doubt.
Enti Solomon Owusu and Ivan Kyei innocent na mote omunka. Me the program no AC and the big man himself Nana Kwadwo Jantua Mobetin Nkawaide on this particular subject on this show, Sokatoa show. Me patcho me the program na si enti e be anybody share mo biom. Bye bye.